We're going to deal with the bond judge first and then decide.
Sent in that motion because the people issued sent in that motion. One made to Farmville Police Department and two made to the Wayne County Sheriff's Office. I'm still awaiting two made reports from Wayne County Sheriff's Office. I'm still awaiting the police report attached to my County Sheriff's Office, but there was Farmville Police report attached to my emergency defendant. There was text when I spoke to her said by the defendant threatening for her safety, and I spoke to her on the phone. I was concerned for her safety, and I found out why Sir Carter has not filed a motion. I'm not sure why Warren Carter has not filed Warren and I would ask that the bond be set at a really high. I would ask that the bond report be set at a really high. Pretty different violation and bond. He also has a pretty different. He has no contact. He also has that we have this. He has no contact. I don't have the no go to that we have to reach out to this case, and so I don't understand.
Mr. Vince.
Well, Your Honor, is the witness here? Because that is all.
Mr. Vince.
Well, Your Honor,
all the allegations are based on
is the witness here? Because that is all police contact.
I mean, no
All the
allegations
no
are based on
third-party
her
witness. There's been
no DNA,
no police contact,
no fingerprints,
no police contact
no
with
third-party
my
witness,
defendant
no
here.
DNA.
So he wants a hearing on this bond violation?
None of these phone numbers connect
defendant
to
here.
his account.
So he wants a hearing on this bond violation?
None of these
absolutely
phone
denies
numbers
the
connect
allegations
to
in here.
his account.
There is no physical evidence
There, and if there's not a
absolutely
witness
denies
here,
the
Your Honor,
allegations
then
in
both
here.
the underlying
There is
case should
no
be
physical
dismissed.
evidence,
And
and
if
if
there's
there's
not a
I'm not
witness
even
here,
talking
Your
about
Honor,
the
then
underlying
both
case.
the
So
underlying
just
case
deal
should be
with what I
dismissed.
told you to deal
And
with.
this
I'm
alleged
not even
violation.
talking about the underlying case.
Absolutely,
So
Your Honor.
just deal with what I told you to deal with.
When do you
want a
have
hearing
the
on
other
the bond
report?
violation?
Absolutely, Your Honor.
I'm not sure, but I can check on that today. And
When
I'm
do you-
also
when are
waiting
you
for
gonna
the
have
actual
the other
screenshots of the text messages that are written. I can check on that today. And I'm also waiting for the actual screenshots of the text messages that are written in the report. And if he's saying that that's not his phone number, I can also get a search warrant as to
In
that
that police
effect.
report, there are 6 phone numbers listed. The police report indicates that none of those numbers. In that police report there are 6 phone numbers Carter's. The police report indicates that none of those numbers. I have not received those screenshots. It's the first time I'm hearing that there are. If there are screenshots, I have not received those screenshots. However, it's the first time I'm hearing that there are 2 officers showed up. I don't know how Wayne County. However, this police report says that 2 officers showed up. I don't know how Wayne County. As far as I can see, there were no Wayne County Sheriff's on the scene. Any different than this incident? As far as I can see, there were no Wayne County Sheriff's on the scene. Simply no of this alleged incident evidence. There's no third-party evidence. Just simply no. If you read through the evidence. There's no third-party evidence.
Before I revoked your client's bond.
Okay, well, I would hope you did.
Before I revoked your client's bond.
Okay, well, I would hope either, when you start to read through it, or he's the luckiest time, either the planet, because it's a lie. I would think that Romulus PD would be able to get over there in the length of time that all of this stuff is alleged. I would think that Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened. Yeah, it went. She says at 1 p.m. He began to call her. And she says at 1 p.m. He got into an apartment, beat on the door of the apartment, left the apartment, started yelling, got into an apartment, and generated somehow all while outside. Left the apartment, 6 other started yelling through the window, 6 different generated somehow all while outside to the defendant. 6 other phone calls from 6 different. If she's not here, Your Honor, none of which then I think that that is a very, very strong indication. If she's not here, Your Honor, then I think that is a very, very strong indication. The other thing in this, Your Honor, this person alleges that he stole a gun from her. The other thing in this, Your Honor, this person alleges that he stole a gun from her. If that's the case, then shouldn't this have been a little higher priority? I think prosecution knows. If that's the case, then shouldn't this have been a little higher priority? I think prosecution knows. There's just this is not accurate. There's nothing before the court today indicate that he is guilty. There's nothing before the court today. If she's not here, she should have been here. He is guilty. There's no Romulus police officers here, not that they saw anything. If she's not here, she should have been here. There's no third party police officers here, not that they saw anything anyway. None. There's no third party in the police report that says witnesses. Banging on the door. Girls outside, supposedly shouting the N-word. Apartment complex. Don't you think somebody would have witnessed that? Girls outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that? Especially without a witness, without some shred of physical evidence. Oh, you're all right. Without a witness, there's nothing. Without just the allegation shred of someone who did not bother, apparently, to show up. There's nothing. This is just the allegation of someone who did not bother, presumably, for the underlying to show up to court, both for this and
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. This defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pre-trial where he's charged with resisting and obstructing a police officer. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer. I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police. Also,
Your Honor, I don't have screenshots.
Also,
Your Honor, I don't have screenshots.
I let you go on and on. I told you what I'm trying to focus on.
Ever.
Keep trying it, Mr. I let you go on and on. I told you what I'm trying to focus on. Real fast. Keep trying it, Mr. Benson. You're gonna run into trouble with it.
I also explained in my motion that Romulus police, I also explained in my other motion that the Romulus police report is different than the two other contacts also had with the sheriff's department. So I'm not sure what those police numbers, I have no idea why in the sheriff's department Romulus. So I'm not sure what he means on different. I don't have idea why the sheriff's department Romulus was here. No, it's completely different, and I don't have the application. I followed the process. I'm awaiting to also, even though they're not in our county, and I followed the process. This is if we're having a bond violation hearing. Also, I would just remind the defense counsel if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond to take what it has in front of it, including the Romulus PD report. So I would ask the court to take what it has in front of it, including the Romulus PD report screenshots and possibly a search warrant for this report. And so I can get some actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be remanded. Given the seriousness of this case and the seriousness of his other two cases, to be remanded. Given the seriousness of this threat to the victim, but to the safety of the community. And I do believe he's not only a threat to the victim, but to the safety of the community. He seems to find it funny, and also defense attorney's children, which also tells me that he does not take this. He seems to find it funny as defense attorney's, which also tells me that he does not take the complainant witness not being present, which also I did not know that he was going to be here. I thought he was present. He was still out since he had not. I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware. Spoke to her, she was out for her life. She said she would continue to answer the phone, but she has been placed in a different place. She said she would continue to answer the phone, but she does not want me to share out loud in a different place that I know that location, that she does not want me to share out loud. She is not present, and regardless if she was present or not, I can still perceive she is not present by wrongdoing. Regardless if she is present or not, I can still perceive based on these other by wrongdoing, and I was going to ask her time to defendant anyway, so that I could present those at trial. So I was going to ask her time to get those anyway, so that I could present those at trial. So regardless if she is here or not, it actually says I have to say if I can proceed or not, which is why I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing.
And if hearsay allegations, someone's not here. This all happened very in the last 48 hours, 72 hours. Allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Two things is not here, first of all, but if I look at what's in here, you're mixing two things. Because certainly they can proceed by hearsay. You're mixing two things. Because certainly they can proceed by hearsay as regards to bond violence. So that maybe we can clear that part up, because so they don't need a final settlement conference. The people have, as to the final settlement conference, that they can proceed. The people have stated to the court if they can proceed, but that they also do know where she is, without her, if necessary, but that they also
I
do
don't
know
know how
where
they
she
could
is.
possibly proceed when there is not a
That's
stitch.
not your
I don't know
issue.
how they could possibly proceed
They
when
made the
there is
representation to
not
the
a
court. That's
stitch.
not your
Okay.
issue.
And I'm making a representation to the
They
court.
made
that
the
when you read the police
representation to the court.
which you have.
I read it.
And I'm making a representation
Then
to
you
the
know
court
that
when
there
you read the
is
police report.
only
you have.
I read it.
Then you
At
know
least
that
for
for
what
what
I
I have in front of me,
only
what
her
you have
allegation.
in front of you. At least for what
He
I
is
have
here.
in front of me,
He's
what you
availing
have
himself to
in
the
front of
court
you.
every time
that I've had anything to do with
he
him.
is here.
Why
He's not
did he
availing
turn
himself to
himself
the
in
court
between
every
the
time
time I revoked
that
his
I've had
bond
anything
today?
to do with him.
Why
He's not
did he
availing-
turn himself in between the time I revoked his bond today? Because you, as an officer of the court, should have instructed your client to do that. That the court. Because you, as an officer of the court, I want an answer to that. Should have instructed your client to do that.
we were going
that
to
the
be
court
here
had
today.
revoked his
That
bond.
is.
That's not an answer to that question.
I mean, we were going
According
to be
what the
here today.
defendant just told
That
us,
is.
That's not an
attorney
answer
is
to my
that,
question.
he told them to
Mr.
just
Allen.
show up today. And what the defendant just told us,
That's
attorney
correct,
is
Your
that,
Honor.
he told him to
That-
just show up today and not turn himself in.
Oh, put me in handcuffs.
That's correct, Your Honor.
That's a wrong answer.
I mean,
Way
put me
the
in
wrong
handcuffs,
answer.
man. I'm sorry.
That's a wrong
Actually,
answer. I'll deal with this in a minute, because right now,
Way
the
the
wrong answer.
I'm
If you
sorry.
would represent that
Actually,
client. I'll deal with this in a minute, because right now, I'm furious, Mr. Court's gonna stand in recess. That client, defendant to remand. Take it, baby. Court's gonna stand in recess. Baby. Yeah. Can you bring him? Somebody back there with him? Can you bring him out? Yeah. Can you
Court
bring
calls the
him?
case of the people
Somebody back there
versus
with
Cameron Crowder.
him? Can you bring him? Recall.
Court calls the case of the people versus Cameron Crowder.
On behalf of the defendant.
Recall.
Yeah, there was absolutely a mix-up. Vincent, on behalf of the defendant. And as much as my understanding was that he had. There was absolutely a mix-up. And as much as my understanding was that he had spoken to the court. And I should have come in. And they did not tell him to come in on my part. And I should have.
Well, it's not a mistake, it's a sanctionable offense.
Absolutely.
And I think you ought to know that. Well, it's not a mistake, tell the client, and I think you ought to know client that they shouldn't in some way willfully tell the client, hey, or
No way
even
of
intimate
shape
to
or
a
form
client
did I.
that they should in some way disobey.
Meant to have that.
Okay.
No way of shape or form was that he had seen you in person. Meant to have that effect. And that my understanding was that he had seen you in person this week. I would never have anyone try to. I would never, I think you know that. Disobey an order. I would never have anyone disobey any of your bond conditions. Knowingly disobey an order. I would never knowingly disobey any of your bond conditions or orders. Horrible mistake, and I'll fall on my sword for it. But it is a misunderstanding. Not a horrible mistake, and I'll fall on my sword. In no way, shape, or form. But it is a misunderstanding. Not any. He certainly is trying to avoid. In no way, shape, or form was I trying to get him to avoid these charges and allegations. He certainly is trying to avoid justice on this, Your Honor. All I can say, Your Honor, is that my understanding was that he had spoken to the court. All I can say, Your Honor, is that my understanding was that he was free to come to the court this week, and that he clearly had come here Friday. At no point did I ever advise Mr. He clearly had anything else other than follow the law. At no point did I ever advise a dozen times to do anything else other than follow the law. Every time I was talking to him, do not violate your bond. Don't violate your bond. A dozen times that. Every time I was talking to him, do not violate your bond. That was the understanding. Show up Friday. It is absolutely a snafu on my part. My understanding was that was the understanding. And it is absolutely a snafu on my part. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL. He's availed himself. I can take to court today, Your Honor. He is working on another job over to jury selection. He's availed himself. Be there then to court today, Your Honor. If this is bound over, he understands this is serious. He'll be there then too. He's just vehement in his innocence. He understands this is serious. Perhaps has been overzealous, and he's just vehement in on my part. And I meant no disrespect to you, overzealous in court, to the people on my part. I meant no disrespect to you, court, to the people.
What to do in this case? Because, I mean, something's got to be decided as to what in this case, defendant, that Because, I mean, something's gotta be decided as to what was told. Court will take whatever action it deems necessary. It be resolved some other way until the court will take whatever action it deems necessary. And I won't do that until, angry as I am right now, I'm not gonna make that appropriate to do so on that. As angry as I am right now, I'm not gonna make that decision. I will set a bond hearing in person in this case. I will set a bond hearing in 2023 at 9 a.m. for all of June 26, 2023 at 9 a.m. At that point. All in the interim, defendant's bond is revoked. We can deal with it at that jury. In the interim, defendant's bond is revoked. We have today as well as the jury selection. Jury final settlement will be August. That we were going to have today as well as the jury selection. Jury final settlement will be August. My next one, August 11th, 9 a.m. 2023. Jury selection at August 9 a.m. 2023. Jury selection at 8:30. August 14th, 2023 at 8:30.
John, my echo.
Defendant's remanded.
John, my echo.
I don't think you want to do that right now. I don't think you want to do that right now.
You know I did not.
I am just